This episode of AHLA's Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hello, welcome everybody to our 8th consecutive installment of the top 10 healthcare antitrust developments in 2025 and the top 10 healthcare antitrust developments or likely developments that we are looking forward to in 2026. I'm your co-host, John Carroll, here in Washington, D.C., and I'm a partner at King & Spalding, where I recently returned just a few weeks ago. And I have the pleasure of being joined by my friend, Alexis Gilman, who is also in Washington, D.C., and a partner at Alston Bird, where he also recently joined, not rejoined, but recently joined just a few months ago. So we were not so self-indulgent and self-centered as to include those as the top 10 developments in 2025. We'll leave it up to you to conclude whether that would be the case. As per usual, for those of you who are returning listeners, we're going to go through 10 through 1, 2025, and then 2026. On behalf of both of us, it's a pleasure to be doing this for the American Health Lawyers Association. Definitely subscribe to their content where available. I will also point out, other than generally pointing out that it's been an extraordinarily active year, that neither Alexis nor I will be giving any editorial comment on any of these developments. This is a Just the Facts podcast highlighting the most important developments. And again, at least in our, we'd like to think somewhat objective view, what we think will likely be very important developments in the year to come. So with that, I'm happy to turn it over to you, Alexis, to kick us off at number 10.
Yeah, thanks, John. Great to be doing this with you yet again. We have a lot to talk about and cover. And as you said, this will reflect our best objective assessment of top developments, but doesn't necessarily reflect our views or those of clients or the firm. But let me kick it off with number 10, missing, of course, at just at 11, which would have been our moves to new firms. But number 10 is just really Trump 2.0 and the effect that's had on healthcare antitrust enforcement. I think you see that in a couple places. One is with respect to personnel. There's a new chair at the FTC, Andrew Ferguson, who was tapped by the president to lead the FTC. He's a former Solicitor General of the Commonwealth of Virginia. Mark Meador was nominated, confirmed as another Republican commissioner at the FTC. He's a former FTC, DOJ, and Senate staffer, and he worked in private practice for a while. He joined in April, and Republican Commissioner Holyoke made up the third Republican for a time, but she's now departed to become the U.S. Attorney in Utah. Another major development was that the president removed both Democrats from the FTC, Rebecca Slaughter and Alvaro Bedoya. Former Commissioner Slaughter is litigating a case to be restored to her seat on the commission. And then over at the DOJ, Gail Slater was confirmed, easily confirmed really, as the head of the DOJ's antitrust division. And we've seen just a whole lot of policy developments. We don't have time to go through them all one by one, and we'll mention a couple of them in other parts of our top 10 for the year, but I'll just point out a couple, which is this administration repealed the Biden administration's executive order on competition, which called for a whole of government approach to competition enforcement, and also called out consolidation in healthcare as one area of concern. The FTC and DOJ, perhaps surprisingly, have retained the 2023 merger guidelines. They've retained the HSR rules that were pushed out by the last administration. They've kept on the books a prior approval policy, which is a little bit in the weeds, antitrust nerd speak for whenever you kind of enter into a settlement in a merger with the government. A prior approval provision gives the FTC the right to give a pure thumbs up or thumbs down on whether they approve the buyer's acquisition in that same market in the future for 10 years. On paper, that policy has been retained, although implementation has been inconsistent. So maybe not, maybe more on paper than in enforcement. The healthcare statements that covered ACOs, information sharing, and some other things that were repealed by the last administration have not been re-implemented, or any plans to restore them been mentioned. antitrust guidelines for business activities that really covered labor issues, which we'll get into later. That came out just before President Trump's inauguration and over the objections of Republicans, but that policy remains in place. So we've really seen a mixed bag on the policy front of things that have changed and things that are consistent and haven't changed from the last administration. So I think that's our number 10 development for 2025. And I'll turn it over to you, John, for number 9.
Sure. So to get a little bit more specific, as Alexis previewed, one of the changes, or one of the developments rather, in 2025 that frankly to me was a surprise and impacts the healthcare industry as much as any other is the fact that the agencies, the federal agencies, the DOJ and the FTC, kept in place the dramatic expansion of the Hart-Scott-Rodino Act rules. So for those of you who are not practitioners, if you are parties to a deal of a certain size and scope, the agencies get a preliminary view prior to close of that transaction and can assess the competitive effects of it. And the information that parties have to each give with respect to that transaction and about their own businesses is called an HSR form. That form had not been really changed much in quite some time, decade plus. And the Biden administration had proposed, new rules that had expanded it by the FTC's own estimation, at least 4x in terms of the time that it would take to provide the information and the amount of information itself that would need to be provided. Those rules were finalized February 10th, 2025. Certainly after Trump had been inaugurated and after, he could have had, his administration could have had the power to place them on hold, to scale them back, et cetera. And so for healthcare clients, I know there's a lot of information that's called for these, particularly for health systems, that doesn't fit neatly into those requests in terms of, identifying supplier relationships, vendor relationships, things like that. It's been a lot of fun. That's my only editorial comment with respect to the new HSR rules, but certainly something that has been a big part of antitrust merger practices and with respect to healthcare and life sciences, they've been dealing with those new rules as well. Turning it back to Alexis for number 8.
Number 8 is a merger litigation challenge brought by the FTC against a couple medical device manufacturers. This is actually the second merger litigation filed by the Trump 2.0 FTC. This one was filed in August to block the Edwards Life Sciences acquisition of Genevalve Technology. In that case, the FTC said that Edwards had agreed to acquire Genevalve within days of agreeing to acquire another company, a competitor, JC Medical. Both Genevalve and JC Medical are developing trans-aortic valve replacement devices for the treatment of aortic regurgitation. I'm sure folks from in the healthcare industry will know what those are, but we'll call them TAR-VR devices. And what's interesting, one of the things that's interesting is that this is really an innovation case where, as most merger challenges are about products that are already on the market, these are about 2 products that are in development that have not been FDA approved yet, or in the midst of that process. And the agency's claims focus on the harm to innovation competition. That also says it'll diminish quality and potentially increase prices. Usually price harm is usually the lead theory in a merger case, but here where you don't have products on the market yet and products may or may not even have planned pricing to go to market, the focus here on this case is innovation harm, which is an interesting aspect of this case. And apparently, according to the complaint, which gets repeated notably a few times in the complaint, the parties rejected the FTC's urging that they divest the previously acquired firm JC Medical. Defendants say that no court has ever blocked a deal where the products are regulated products that are still in development, and that the combination of these 2 firms combines complementary capabilities and really is the best chance to resolve some manufacturing issues that the target company, Genevalve, apparently or purportedly has. This case is pending, but really an interesting case in terms of the development of innovation competition law in the merger context. So certainly both a key development for 2025 and certainly also one to watch next year as well. John, I think you got next.
Sure. So turning to number 7, non-competes. In the news a lot over the last couple of years, and some of you may have noticed that, just a couple of months ago in September, the FTC dropped its defense of the non-compete rule, which had been challenged in a couple of places, including in the Fifth Circuit. But they are not finished when it comes to the non-compete issue, and so they've issued a request for information and letters that are focused on healthcare employers. Going to talk about this a little bit more. I don't want to spoil what we're looking forward to, but healthcare antitrust competition issues and non-compete certainly not going anywhere. But it was a big development in 2025 that the FTC took steps to dismiss its appeal and to not enforce the national rule. Turning it back to Alexis for number 6.
Sure. This is involving the multi-plan class actions. These are class actions filed by healthcare providers against multi-plan and a group of payers alleging that they had illegally fixed prices of out-of-network provider rates. And the allegation is that instead of using usual, customary, and reasonable benchmarks based on publicly available pricing information, charge data in particular, that multi-plan had this algorithm that combined these insurance out-of-network rates, and that the plans allegedly stopped competing with one another to negotiate out-of-network with providers, and instead delegated their negotiation of rates and the actual out-of-network rates to multi-plan and its algorithm. Defendants in the case filed the motion to dismiss, arguing, among other things, that actually this multi-plan offered a new product, offered another alternative option for insurers to calculate out-of-network rates, and this had the effect of actually lowering rates to payers, and ultimately those savings would be passed on to patients. The DOJ, not a party to the case, but filed a statement of interest in the case, and in that statement of interest argued, didn't take a position on the merits, but said that use of a common algorithm to set any aspect of price, either a starting price or a maximum price, can be concerted action that constitutes price fixing and restraint of trade, a Section 1 violation of the Sherman Act, even if the insurers in this case retain some pricing discretion, and even if their end out-of-network rates varied among one another. The DOJ also took the notable position that information sharing through a third party can still violate Section 1 of the Sherman Act. So in June, the district court rejected the defendant's motion to dismiss the case, saying really less so about using the algorithm because it wasn't clear that confidential pricing information was being included in the algorithm, but more that communications between the defendant insurers and multi-plan had exchanged price information, and communicating price information with your competitors was against your self-interest, which might suggest an unlawful agreement, and that even if savings were passed on to consumers, that wouldn't justify a per se unlawful price fixing agreement. So that was the basis for rejecting the motion to dismiss. So that case is ongoing, but certainly a notable development in that class relating to information exchange, outsourcing of administration of rates and negotiation of rates, and even algorithmic pricing. So again, another case of big development this year, but one that will continue to be monitoring next year as well. John, let me turn it over to you for number 5.
Yeah, so number 5 is interesting, and I think is consistent with the theme that Alexis laid out at the beginning with Trump 2.0, which is, we've been surprised, I think both of us as practitioners, just how active the Trump administration 2.0 has been with respect to federal antitrust enforcement, and healthcare is no exception to that. So with that windup, number 5 is the launch of the anti-competitive task force by the agencies. Back in the early part of the year, January 31st to be precise, Trump had signed an executive order, stating that the policy of the executive branch was that the federal agencies should, quote, alleviate unnecessary regulatory burdens placed on the American people. Subsequent to that, he signed another EO that directed agencies to review all identifications and identify regs that, among other things, quote, impose undue burdens on small businesses. And consistent with that, the antitrust division was going to be, part of that. And so then flash forward a couple of months into the spring, and an anti-competitive regulations task force was launched to look at regulations in a number of industries, housing, transportation, et cetera. But healthcare, right? This is a healthcare antitrust podcast. Healthcare is one of them. And the language here, and public comment, by the way, was open until the end of May. Language here with respect to healthcare states that laws and regulations in healthcare markets too often discourage doctors and hospitals from providing low-cost, high-quality healthcare and instead encourage overbilling and consolidation. These kinds of unnecessary anti-competitive regulations put affordable healthcare out of reach for millions of American families. So this is a statement from, Trump's Justice Department with respect to consolidation in healthcare. Public comment period, there were a lot of comments that came across. I imagine the agencies are digesting them. Often what we've seen is where there are these investigations or these public comments or RFIs, whatever they are from the agencies, that what follows is some form of action. And so we'll be looking to see what happens next in terms of anti-competitive regulations that were identified by the task force. And then I have the pleasure of going next for number 4. Number 4 is a bit more specific, which is the Amedisys United transaction that finally settled not that long ago. Home health transaction. It settled on August 7th of this year. And, for those of you who may not be following with bated breath every development in antitrust, one change that was fairly notable under the Biden administration was, I guess, to put it mildly, a reluctance for settlements, divestitures, to remedy concerns in transactions. And so this was kind of back in settlement land, big divestiture, 164, I think, businesses that need to be divested. There's a lot of information on this that's publicly available. Large, significant transaction that got to close, and the parties are now in the process of divesting a lot of assets. So that was number 4, and happy to turn it back, Alexis, to you for number 3.
Right. Number 3 is a case unsuccessfully challenging another medical device case. This one was filed in March by the FTC and a handful of state AGs that sought to block GTCR's, a private equity firm's acquisition of Surmodics. This is a case where the government alleged that GTCR had a subsidiary Biocoat, and by combining Biocoat and Surmodics, which both provided outsourced hydrophilic coatings. These are coatings that go on medical instruments that are inserted in the body, and the coatings obviously help those instruments go in more smoothly and cause less damage to the body. The government in that case was alleging that combined, the two firms would have a combined 60% market share for outsourced hydrophilic coatings, and as a result, the usual allegations of higher prices, lower quality, harm to innovation would result from the transaction. The defendants in the case raise a couple main arguments. One is that the FTC got the market wrong, that the parties either were in different markets because they provided two different types of hydrophilic coatings, one based on thermal curing of those coatings and the other based on UV light curing of those coatings, or that the market was under-inclusive because it was only capturing the outsourcing of the coatings as opposed to including the coatings that were able to be insourced by OEMs who could do this in-house themselves and just coat their own instruments and devices. The other main argument was that the parties had proposed just before the case went to trial that they would divest a number of assets of Biocoat to a divestiture buyer Integer that eliminated the competitive concern. And in November, we got a decision on the preliminary injunction motion, the case in the district court in an oral ruling and no intent to issue a written opinion, so that's kind of notable. The district court denied the motion for preliminary injunction. In the case, the the court said that the government's market definition was too narrow in including just the outsourced hydrophilic coatings. It should have included captured the in-source availability of OEM to in-source hydrophilic coatings. Even so, it was kind of interesting. The court still said that the plaintiffs had sufficiently alleged a prima facie or met their prima facie case. I'm not sure how that works. Usually, if you don't define the relevant market correctly, that kind of ends the case. But in this case, the decision went on. The court went on to say that the market shares were overstated by the government and that the defendant's market share calculations reflected the commercial realities more accurately, and those shares were, much, much lower, less than 30% relative to what the FTC and the states were alleging. And finally, the court was convinced that the divestiture would resolve any competitive concerns, and the court was convinced that the divestiture buyer was adequate and had the intent to compete in the market. So this was the first filed merger litigation filed by this Trump 2.0 FTC, and it was the first loss by the FTC. So I think it's an interesting case. It also shows that defendants are able to defeat the government in market definition, challenge their market share calculations, and litigating the fix is still a viable way to challenge or defend your merger, and that seems to be succeeded here. So that was number 3, and number 2 goes over to you, John.
Yes, and the government also, with respect to defendants, has gotten some wins in criminal cases, right? So number 2 is the United States against Lopez, US v. Lopez, where the Antitrust Division of the Department of Justice got their first big criminal conviction for nurse wage fixing. This is a healthy reminder to our audience that antitrust is not just about deals, it's not just about litigation, but that the antitrust laws also have criminal liability. And so this was a case against someone who was alleged and then convicted of conspiring to fix the wages of nurses. This is someone who was then sentenced to, I believe, 40 months in prison, and also convicted and is going to pay over $3 million in fines and restitution, as well as having to pay back, I think, the $10 million or so from the allegedly fraudulent sale of his business. So U.S. v. Lopez, wage fixing with respect to nurses. Editorial comment here. I think any antitrust practitioner would advise clients to be very careful when it comes to information sharing, and certainly not agreeing, not just on some of the things you may be thinking about, but also with respect to compensation, as there can be potential liability. So, Alexis, you have the honor of number 1 in 2025. I'll turn it over to you for that.
Number 1. So where we landed on this, and I suppose there's always up for debate, but number 1, this year we have the Blue Cross Blue Shield settlement in the provider case. This is a settlement that received final approval in August from a district court judge in Alabama. It's a $2.8 billion settlement in a case that started way back in 2012 against the association and nearly 36 member plans. This settlement is, again, the provider class, which is different from an earlier settlement that's going on about 5 years now. That was $2.7 billion with employers and individual subscribers. We obviously don't have time to cover the case, but just as a super quick reminder, this really related to the allegation that the defendants had unlawfully divided up the country into exclusive territories, so-called market allocation in antitrust terms. And in addition to the multi-billion-dollar monetary relief, the settlement includes other conditions on the association, make internal changes to operations to make them more transparent, more efficient, upgrades to technical capabilities, including millions of dollars in spending on improving claim systems and other conditions related to making data more readily available. Despite this very large monetary settlement, a number of providers have decided to opt out of the settlement and are bringing direct actions. So while this settlement is our number 1 development for 2025, this is yet another case that will continue on for at least into 2026, and if not for years to come. So that's our wrap on the top top 10 developments for this past year, and we'll turn it over to John to kick us off on what we expect to be the top 10 developments in 2026.
Yeah, so this is what we're watching, right? And this is a bit speculative, but just kind of forecasting. I mean, who could have predicted what happened in 2025? I didn't go back and look at our track record, Alexis, but I should also point out and should have started this is being recorded on December 8th. And so want to particularly emphasize this in case we're wrong about anything that we're predicting. And in fact, I'll caveat it further by saying technically this is simply what to watch for. So we are not making any actual predictions. These are just things we are monitoring for 2026. Number 10, midterm elections, right? Like we're both sitting here in Washington, D.C. Can't help but not ignore what's happening politically here with our federal government. We have some very significant midterm elections coming up in the fall, and look, antitrust is no stranger to congressional investigations, and so whether that is a House Judiciary Committee investigation of a company, of an industry, of an agency, depending on who takes Congress and who's in leadership. There could be a lot going on, or there could be very little. So again, not predicting, but it is something that we are keeping our eye on and will be keeping our eye on over the course of the next year. Alexis, number 9.
Number 9 is, are we going to have any more new FTC commissioners? As I kind of alluded to earlier, the president removed the 2 Democrats on the commission, and one of the Republicans departed for another post. So there are now 2 Republicans left on the commission, which the FTC can operate that way and has before. That's sufficient for a quorum. There's been reports that the president may nominate Ryan Bash to fill one of the Republican seats. He's currently on the National Economic Council in the White House as a special assistant to the president for economic policy. Apparently, he focuses on tech and AI issues and other issues, and he previously worked in the Texas Attorney General's office. But beyond Bash, it's not clear whether we're going to get any more nominees. As I mentioned, there's a Supreme Court case being heard today for one of the Democrats, former FTC commissioners, that's trying to be restored to a position. And this case is really about whether the president has the authority to fire heads of independent agencies without cause. And if the Supreme Court says he does, it's not clear that we'll necessarily have any Democratic nominees to the FTC, and could see certainly a big change at the FTC about what nominations look like both in this administration and going forward, about whether we see minority party commissioners being nominated and confirmed to any independent agencies, including the FTC. It's not clear what incentive they would have to nominate, but even if such minority party nominees got posted to the FTC, the president could presumably fire them without cause the next day if this case, Trump v. Slaughter, goes the way many are predicting. So we'll all be watching what's going to happen with the leadership of the FTC going forward in light of this Trump v. Slaughter case. So that's number 9, and you could really move that up potentially higher up the list. But for now, let's turn it over to John for number 8.
Yeah, that's the fun with looking at things to watch for, right? It's hard to rank them because it depends on what happens. But just kind of sticking with the political theme a bit here, or the congressional theme, there was a hearing back in, I think it was May, in the House Judiciary Subcommittee on the Administrative State, Regulatory Reform, and Antitrust. So I was calling them just HJC, and that wasn't quite accurate earlier. But this is, one of the primary groups really over in Congress that examines antitrust. And with respect to healthcare, there's been concern, right, about shortages with respect to providers, just particularly in rural areas, but just more generally. And so folks may not know, but there is an exemption from antitrust, because otherwise it would be independent actors getting together and agreeing on things they shouldn't agree on with respect to the medical residency program. So there's been a lot of noise around ending that exemption. There was a hearing on it. Who knows what's going to happen with Congress? It concerns healthcare, and so those are the building blocks as to how we got to having this be something to take a look at and monitor. And we'll talk a little bit more about residency programs going forward by way of preview. But that's essentially why that gets us to 8. Alexis, I believe number 7 is all you.
Yeah, this is the Good RX class actions, and it's really kind of a sister or cousin case, I guess, to the multi-plan case we mentioned earlier. This is consisting of about a dozen class actions filed by pharmacies against Good RX and 4 PBMs that represent about 64, according to plaintiffs, 64% of all filled prescriptions in the U.S. And what the plaintiffs allege in this case is that PBMs use GoodRx's price aggregation algorithm to fix the prices that they pay for generic drugs dispensed by independent pharmacies. Basically, according to plaintiffs, PBMs are using this pricing technology in their claim systems. About 95% of PBMs representing about 95% of prescription claims allegedly participate in some form of information sharing with GoodRx. And according to plaintiffs, this means that the PBMs through this GoodRx system are basically pay the lowest price that any PBM has with the pharmacy for the generic prescriptions. Therefore, the plaintiffs say the rates that paid, the fees paid to independent pharmacies by PBMs have gone down, and rather than compete for those payments, they're using GoodRx to align their pricing. These cases were recently consolidated in a Rhode Island MDL. Again, this is just another in a line of cases kind of relating to algorithmic prices, using a third party to manage pricing to counterparties in the payment system. So another area for really anyone in the healthcare industry to watch when it comes to payments, GPOs, PBM issues. So a continued area to watch in 2026. That takes us to John's next one at number 6.
Yep, number 6. By the way, we previewed it 20 minutes ago or so. What's going to happen with non-competes, right? I mean, we've got different layers to non-compete enforcement. There's sort of state law, contractual enforcement, right? Private litigation. But, more in the arena of federal antitrust enforcement. We just don't know what's gonna happen since the FTC, voluntarily dismissed its case a couple of months ago, as I said, I think at least in the Fifth Circuit. And so, this is something where, notwithstanding its dismissal, the agency said that they're going to, take, I think it's, to use the healthcare metaphor, more of a scalpel when it comes to non-compete antitrust enforcement. They believe in their authority. They believe that that non-competes in certain instances are anti-competitive. And so this isn't something that's just completely gone away. The question is, what's it going to look like? What's this enforcement going to look like? Is it going to be part of a merger investigation, a settlement pursuant to that, right? Is it going to be just an outright, investigation of a non-compete arrangement by a healthcare company of some sort? And what authority is that going to be brought under? I mean, to get a little more specific on the antitrust, you've got, authority to enforce Section 1 of the Sherman Act, certainly by DOJ, or Section 2 if the healthcare company were to allege to have market power. But then we've got Section 5 of the FTC Act, which is under, almost seemingly decades-long discussion around the scope of that authority to bring actions with respect to unfair competition and whether that sort of exceeds the FTC's authority beyond what's coextensive with the antitrust division. So with all that, I think it'll be interesting to see, and we'll be watching kind of what happens with non-compete enforcement, particularly in the healthcare space. Alexis, back to you to start us off in the top 5.
Yeah, the Section 5 mention is a good segue to this next item watch for next year, which is the FTC's case against PBMs in administrative litigation. So this was a case started by the Biden FTC, sued 3 large PBMs and their affiliated GPOs. It was filed in as an administrative case, so not in federal court. And the FTC is what we call Part 3 administrative trial process. And in that case, the FTC alleges that the PBMs extracted higher rebates, higher rebates through exclusionary drug formularies related to insulins, basically in what the FTC calls a chase the rebate scheme. The FTC says that these rebating practices incentivize or encouraged and resulted in higher list prices because in order to secure higher rebates, PBMs excluded lower cost insulins from formulators in favor of higher cost drugs, and as a result, consumers were paying higher prices. And what's notable, or one of the things that's notable about this case, is not the FTC not alleging any Sherman Act violations, but a pure Section 5 claim that these rebating practices constituted an unfair method of competition, as well as an unfair act or practice under Section 5 of the FTC Act. Case originally stalled for a little bit due to commissioner recusals. Chair Ferguson unrecused himself, so the case picked back up again, and the defendants have filed a motion to dismiss, raising a bunch of defenses: failure to define a relevant market, failure to allege any harm to consumers, failure to tie the rebating practices to the harm. So that motion to dismiss is pending, but obviously, given sort of widespread concern about the pricing of pharmaceuticals across parties across Washington and across the country, I think this is one case to continue watching as sort of another way that the administration seems to be trying to tackle high cost of prescription drugs, but certainly an important case also for antitrust purposes in terms of the FTC's Section 5 authority. So that's number 5. Let's turn it over to John for number 4.
Yeah, so a bit more nascent, but there have been several class action lawsuits filed earlier this year alleging, a number of systems that alleging that the pharmacy residency match system, so maybe not something that's subject to that exemption, no editorial comment, whether there's this violated the antitrust laws through the suppression of low wages. Sorry to give this short shrift, but something that's just filed, something to keep our eye on, and we'll see sort of what happens in the class action space here as we get into 2026. So sorry to be so quick, Alexis, and put you on the spot back for number 3.
Yeah, this is another nascent case, so this will be relatively short too. This relates to contracting practices by a hospital in New York, and there's been a report in the New York Times that the DOJ is investigating New York Presbyterian's contracts, which allegedly include some anti-steering and anti-tiering provisions. We've also seen a case filed in September by a union related to these contracting practices, that the hospital's contracts allegedly included anti-steering provision, all products clauses, and terms that allegedly suppress price transparency. These are issues we've seen in prior cases. We saw them in the DOJ in North Carolina case against what was then called Carolina's Healthcare that ultimately settled. We saw this in California when the AG and some private cases sued Sutter Health. Those cases have now been settled, so it'll be interesting to watch this particular case, but also whether we see more antitrust enforcement against providers' contracting practice, especially multi-hospital systems, where they may negotiate all of their hospitals together, and whether we continue to see an increase in complaints or concerns about these types of contracting provisions. So that was number 3, and John, you have number 2.
I do. Happy to be talking second to last about what we're going to be looking at. So, folks may remember, the roll-up action FTC brought against a private equity firm, and some in the anesthesia space, forgetting, at least, frankly, even I kind of forgot a bit that there was still the action by the FTC against USAP, U.S. Anesthesia Partners, forgive me. In fact, just recently, right, there were some motions regarding the shutdown. Now the FTC is back, as are the rest of the agencies, alleging sort of different monopolization claims that USAP grew of a certain size illegally. And so, look, we'll see, what happens on this case as well. Sort of consistent with our theme, I guess, big picture. It's what's the government going to do? What's going to happen on actions the government's already taken? And then what's going to happen in cases that have been being brought? The harder thing overall, kind of just pulling back from the list and specific actions is, we don't know what's going to be filed, right? And I mean, if we do, then Alexis and I aren't saying anything about non-public actions we're involved with, certainly. So that's the big sort of number 11, Alexis. I'm not trying to steal your thunder from number 1, but of course, there could be any number of interesting pieces of litigation filed in the healthcare space. It's a complicated industry filled with, a lot of players with a lot of different types of incentives. There are all sorts of deals that could be announced, and the government's always hard to predict. So we'll be watching for a lot more than just this top 10 list, but I think this, at least through, as Alexis takes us home with number 1, those are sort of the themes that we've been seeing from the last year and looking forward into the next one.
Yeah. Maybe this reflects a little bit of our merger practice bias, but we selected our number 1 topic to be the seeming proliferation of state mini or baby HSR bills and laws being passed. As folks may know, more and more states are passing pre-merger notification, filing requirements, beyond what is currently required under the Federal HSR Act. I think currently there are about 15 states or so that require pre-merger notice requirements for healthcare deals in particular. There's a couple states, Washington and Colorado, that recently passed legislation that requires parties to submit copies of their HSR filings if their state-specific thresholds are met. And one thing that's can be challenging for merging parties given this proliferation of state laws is that a lot of these requirements in the states are different in terms of which transactions require notification, what is required in the notification, what is the timeline for the review period to the extent it suspends closings. So there's a lot, and this obviously makes things more complicated, more time consuming, and more costly for merging parties the more and more of these that are passed by the states. So one thing to watch in 2026 is if we continue to see this trend across states, how states go about implementing these laws and how it affects, the merger review process for merging parties. And in turn, what does this mean for state enforcement of mergers enforcement? We already see a time AGs are as active as ever in merger enforcement, and certainly these laws would seem to give them a greater ability to be even more active in examining and potentially challenging mergers, particularly in the healthcare space. So that's certainly the area we think bears watching in 2026. So that's our totally objective, no room for argument list of things to watch in 2026. But John, defer to you on how to close this out.
Really appreciate it, Alexis. It was the 8th time. I think they keep getting better. So congrats on your move. And we look forward to speaking with you in just about a year. Take care, everybody. Thanks so much.